for orders, item 1, IA Criminal 2 of 2026 pertaining to alcohol ban.
Yes, who's there? Can you hear us?
Yes. Yes.
PP has arrived today. PP is there.
Yes, Your Lordship, appearing on behalf of Ms. Vanessa, as she is now on leave.
What happened to her?
She's at Darjeeling, dealing with admission for Hassan.
Oh, I see. Out of station.
Yes, Your Lordship.
Yes, Mr. Pianfella, what do you say about this application? Why have you filed this application?
Yes, I have filed this application, Your Lordship, because in the last page of the judgment,
Yes.
the further proceedings in this case is to be conducted by the learned district and session judge, Champhai.
Okay.
But on 19/4/2017, a notification was issued by the Secretary to the government of Mizoram, by which additional district and session judge Champhai was designated as special court for the purpose of the POCSO Act.
Mm.
So, while we have approached the district and session court Champhai,
Mm.
the district and session judge told me that I have no power to entertain this case because I have no power because of this notification. So I have come here for modification of the judgment, with a prayer for modification of the judgment. With
Okay.
regard to the-
Earlier, who had handled this matter? The judgment passed by
Fast track special court Champhai.
fast track special court.
Oh, fast track court of fast track special court, rape and POCSO Act.
Okay. It's a different court, isn't it?
Yes, it's a different court.
The district and session judge also is a different court now.
Yes, Your Lordship.
And we have the court of additional district and session judge
Yes, Your Lordship.
in Champhai.
Yes.
Is it the same officer or
No.
different person?
In the district and session judge, Honorable Dian Sangzuala,
Okay. And the additional
Yeah.
district judge?
Abigail Hingthan Pari.
Okay. And the special court?
I don't know exactly now, Your Lordship.
Special court, you don't know?
Yes.
Under
Before
POCSO
that,
Act, the special
Could
court
be
was
side
there?
Punga. Yes.
Okay. Champhai. Which one? PP is not there today.
Well, Your Lordship, as per her instruction, we have no objection.
Now, do we have any special court in Champhai?
I don't know the exact position now, my lord.
File this application, when do you want to go?
No, the thing, there is an additional district and session judge there, and who has been employed under this 2017. So that can go to that. It is positive. Well, Art Mr. Lal Pianfella Chongfu, learned counsel for the applicant, and Miss
Lal Sang Zeli, Your Lordship.
Lal
Lal
Sang
Sang
Zeli,
Zeli, yes.
Lal Sang Zeli,
Yes, Your
learned
Lordship.
counsel on behalf of Miss Vanessa, learned additional public prosecutor. Stop by filing this application. The applicant prays for modification of the judgment and order dated 4/9/2025, passed by this court in criminal appeal number 6 of 2025. Insofar as remand of the case to the district and session judge Champhai is concerned. Stop. The learned counsel submits that White notification dated 19/4/2017, issued by the Secretary to the Government of Mizoram, Law and Judicial Department. The Governor of Mizoram has designated the Court of Additional District and Session Judge Champai as special court for the purpose of the POCSO Act with the approval of the Gauhati High Court. Stop. Such being the position, the applicant prays that the case may be remanded to the learned additional district and session judge. Stop. We have noticed that the earlier judgment and order was passed by the presiding officer, oblique judge, Court of Fast Track Special Court, bracket Rape and POCSO Act 2012, Champai. And this court, upon considering the appeal filed by the applicant, was of the view that the matter should now be taken up not by the same court, but by the district and session judge Champai. In the interest of fairness. From the stage of examination of the accused person under section 313 CRPC. By placing all the materials questions to the accused person, which may be regarded as incriminating circumstances appearing in the evidence, and thereafter to pass the judgment afresh after hearing the parties. Stop. Next para. We have considered the submissions made by the learned counsel. Oh, before that, you cancel that. Miss So-and-so, learned counsel appearing on behalf of Miss Vanesiami, learned additional public prosecutor, submits that as per the instructions received by her, the state does not have any objection if the application is allowed. Next para. We have considered the submissions made by the learned counsels for the rival parties, and we have perused the materials available on record. From having regard to the notification dated 19/4/2017, wherein the additional district and session judge Champai has been specifically designated as the court of designated to deal with matters under the POCSO Act. We are of the view that there is substance in the prayer made by the applicant, and accordingly, the matter stands remanded. And accordingly, the judgment and order of this court dated 4/9/2025 is modified by relegating the matter to the additional district and session judge Champai instead of the district and session judge Champai. Stop. But for the above modification, the remaining part of the judgment shall remain the same. Stop. With the above observation and direction, the application stands disposed of.
Oblige, Your Lordship.
Yes.
I beg to mention item number 23.
23, what do
Yes.
you want? You want to
At
upgrade?
least after 1 week.
You want to upgrade?
No, Miller.
You want
At
adjournment?
least after.
Why you want adjournment?
Miller, actually what happened, Miller? Last occasion, a file is missing, Miller. Today trace out the file, Miller.
File is
Today
missing.
morning.
Your file is missing.
And missing, but today trace out in the morning.
Oh, today you've traced out.
That time. And next week, any date.
Brother, we don't give a date, let them. Okay, Mr. A.M. Ahmed, learned counsel for the appellant submits that he had misplaced his brief. And the same was recovered just today. And therefore, he needs some time to prepare the matter. In view of above, and as paid for, matter stands adjourned for a week. To be listed again on the date to be fixed by the registry.
Lordship, I beg to mention an IA for distinct, your lordship, in connection with the criminal appeal. So I,
Suspension,
yes, your lordship.
when did you file?
I filed it, on 21st October, your.
Last year?
Yes, your lordship. The appeal was filed on 21st October and the IA was filed on 17/9/2020.
Okay, see, I'll request you to approach the registry for that.
Your lordship, there is special circumstances in this case, your lordship. The victim herself in this case had filed an affidavit saying that she had settled the matter, your lordship. And that is part of the main criminal appeal also, your lordship.
Maybe, but you take it up with the registry for early listing.
On
Okay,
possible, your lordship, on 19/20.
no, please take it up with the registry.
Oxford, 376.
They'll list it, take it up with them and they'll list it accordingly. Many cases are pending actually. Once we start giving dates, every dates have to be given. So now they are compiling, registry is compiling, depending on the urgency and upon the seniority, they're compiling. So wait for your turn, okay? Next,
Lordship, I beg to mention item 8, your lordship. The matter has been settled out amicably by the parties.
which one?
Item 8, your lordship.
Item 8. How it is settled?
Lordship, they have settled amicably and all the pending cases before the learned trial courts are drawn, your lordship. So we have
I
the
don't know.
instructions from the petitioner to withdraw this matter.
Withdraw this matter. You want to withdraw the criminal revision petition?
Yes, your lordship.
Now, another aspect is that whether this matter is to be handled by single bench or DB.
Lordship, it was listed.
It was listed before single bench earlier.
Yes, your lordship.
Now, today is listed before DB. Why? Hold the file, give the file. Maintenance. This is an against the interim order for maintenance.
Yes, your lordship.
But,
But that case was withdrawn, your lordship. Later on.
okay, before that, my query was whether it should be placed before this bench or a single bench.
It was earlier mentioned, listed before single bench. Family court. That's it. It is come from a family court. Yes, sir. Yes, sir.
What is that? Sorry. All the time it was listed before single bench. Suddenly it appeared. There's no note also. And plus, it had gone for mediation.
Your lordship.
It had gone for mediation.
Yes, your lordship.
And deed of settlement also signed. Yes, you are there?
No, no, but it's.
Oh, I see. Who's for the opposite party? You are MAI Hussain,
MAI Hussain, I'm on behalf of MAI Hussain.
on behalf of MAI Hussain. Then respondent is state PP, then your formal party. Number two is the necessary party. Panchali Medhi. Is she represented? Now that PP, what do you say? Is it a matter to be dealt by a division bench or single bench? Ah. Dated? No, come on. It's two more judges. Division bench. This is by division bench. Oh, this is appeal. It says appeal and revision. You have instructions to withdraw.
Yes, sir.
Appeal, this is revision. What is your good name?
Yes, allow me, election.
Mr. S. Alam, Learned Counsel, appears on behalf of Mr.
MAI Hussain.
MAI Hussain and submits that he has instructions to withdraw the revision petition since the parties have come to an amicable settlement. Stop. It is seen that this revision petition was earlier listed before the single bench, but now it has been listed before the division bench. In terms of the notification number 30, dated 22/5/2024, issued by the Registrar General of this court, wherein it is provided that matrimonial appeals / matters arising from the orders and judgments of family courts shall henceforth be listed before the special division bench of this court. So apparently, it is because of this notification that this matter has been listed before us today. Who is appearing for the opposite party? Learned Counsel, Mr. R.R. Kaushik appears, Learned Additional Public Prosecutor, Mr. R.R. Kaushik appears for the respondent number 1 and submits that the state is only a formal party. Stop. No one appears for the respondent number 2. Stop. However, as the revision petition is seeking withdrawal of this revision petition, we find no difficulty in passing appropriate orders. Stop. In view of above, and as paid for, the revision petition stands disposed of as withdrawn.
Let's do it.
Wait, we should answer. Wait, this is also.
Yes,
My lords, I beg to mention for listing of an IA for suspension of sentence. In the admission part.
IA should come, you approach the registry for listing, okay?
May I please, your lordship, I beg to mention for listing one WPC FT matter, lordship. FT matter, lordship.
Why before this court?
Lordship, because petitioner is in custody since 2/11/25.
Oh, because of that
Lordship. Monday or Tuesday maybe.
No, they can mention before this court today. There's a notification. Mm. What is the urgency?
Lordship, petitioner is in custody since 2/11/25. Here is the urgency. Lordship.
And when did you file the writ petition?
On 2/2/26, 2nd February.
You should have, if there was urgency, you should have filed it last year itself. Miss, you approach the registry, okay? They'll get it listed.
Daily list item 1 for admission.
In. No, I don't want. DLP. Under what section? Page number? Against the judgment and order dated 24/9/2025. Passed by the Special Judge Nogam. A Special Judge within bracket POCSO, Nogam. In special POCSO case number 92 of 2024, by which the appellant has been convicted under what is that? 66.
Sorry, madam, I was holding wrong file.
Hmm?
I'm sorry, but I was holding wrong file.
Okay, it's okay. It should be in clear terms, no? The conviction is under suasion. Where is which paragraph? Last page. It's and 506. This is in the form of a chart. Now, in the judgment itself, where does he write? No, this is the sentence. No, this is the sentence. Sentence will be the second part, first part should be conviction. Judgment should be in clear terms. Hmm. This we have to take up. Okay. Whereby the appellant has been convicted under section 6 of the POCSO Act as well as under section 506 IPC. So upon his conviction, he has been sentenced to undergo rigorous imprisonment for life and to pay fine of rupees 10,000 with a default clause for conviction under the POCSO Act and rigorous imprisonment of 1 year with fine of rupees 5,000 for conviction under the IPC. So both the sentences have been directed to run concurrently. Next para, admit the appeal. Issue notice to the state. Mr. R.R. Kaushik, learned additional PP, accepts notice on behalf of the state. Registry to furnish requisite papers to him within 2 days. Stop also issue notice to the complainant to the office of the additional public prosecutor, who shall in turn cause notice to the complainant through the officer in charge of the police station concerned. Stop registry shall furnish the notice in a proper format to the learned, to the office of the additional public prosecutor within 3 days. Whereafter, notice shall be served to the complainant to the officer in charge of the police station concerned, and the service report be returned back to this court to the same office. List the matter later on now. List the matter on receipt of the LCR.
On remittable license.
Since one, my class may be
That will be appointed. Let the reports come. There's no hurry.
The statutory appeal, my appellant has been convicted under section 4(2) of the POCSO Act as well as under 65(1) of the BNS violence by the learned special judge POCSO Kamrup Project. And corresponding sentences undergoes rigorous imprisonment 20 years, my lord, and fine of rupees 20.
Let me be appeal. Heard, Mr.
A. Mubarak.
A. Mubarak, learned counsel for the appellant, who submits that the instant appeal is directed against the judgment and order dated 11/9/2025. And also the order dated 24/9/2025, by which passed by the additional sessions judge, special judge POCSO, Kamrup Metro, in session special case number 221 of 2024, whereby the appellant has been convicted under section 4(2) of the POCSO Act, as well as under section 65(1) of the BNS, and sentencing him to undergo rigorous imprisonment for 20 years for conviction under the POCSO Act, with fine of rupees 20,000 with a default clause, and for another period of 3 years for offense, for conviction under the section 4(2) of the POCSO Act. What about this 65(1)?
61 already, 4(2) already convicted, my lord. That is why in FPS 43, my lord.
Two separate sentences.
No separate sentence. my lord. That's 44.
Stop. Learned counsel submits that no separate sentence has been passed under section 65, bracket 1 of the BNS 2023. Next para, let the appeal be admitted. Call for the TCR. Acha, earlier order didn't say TCR. Just TCR, okay? Call for the TCR, issue notice to the state as well as to the complainant. Mr. R.R. Kaushik, learned additional PP, accept notice on behalf of the state. Appellant. I have seen in some cases that soft copies are being furnished. Should we do that? Soft copies of the appeal petition for service to respondent number 2.
See what is convenient, madam.
Sorry,
See what is convenient, madam.
whichever is convenient.
The soft copy also sometimes directly they send to us, then we send to the police station. But as per the notification, the usual route is through registry, then registry to our office, then from our office to police station.
But appellant to furnish a copy of the appeal memo to the registry, to file a copy of the memo of appeal before the registry of this court, and the registry of this court, along with the notice to be served to the respondent number 2, shall serve the same to the office of the additional public prosecutor. Stop. The additional public prosecutor shall thereafter cause service of the notice to respondent number 2 to the officer in charge of the police station concerned. And the officer in charge shall report back about delivery of the notice to the same office. List the matter. Again on receipt of the LCR.
In the cause list, my lord, our name has not been shown, my lord.
Name of the counsel for the appellant being shown in the cause list. One more line. You have received the copy?
My lord.
Okay.
I is there, my lord,
IS for what?
for suspension of sentence, my lord.
Okay. Art, Mr. A. Mubarak, learned counsel for the applicant, who submits that by filing this application, the applicant seeks suspension of the sentence passed by the learned additional session judge, special judge, POCSO, Kamrup Metro, in session special case number 221 of 2024. Convicting and sentencing the appellant under section 4, bracket 2 of the POCSO Act, as well as under 4.2 only, isn't it? Sentence is only under 4.2.
4-2.
Okay, 4 bracket 2 of the POCSO Act. Issue notice to the state as well as to the complainant. Mr. R. Kaushik, additional PP, accept notice on behalf of the state. Applicant shall take steps to serve notice to respondent number 2 by submitting a copy of the application to the registry. And the registry in turn shall furnish the same to the office of the additional PP along with the notice format to be served to the respondent number 2 to the office in charge of the police station concerned. The officer in charge of the police station concerned shall report back to the office of the additional PP. List again with the main appeal.
Kind of it.
Respondents are at liberty to file objection to the IA, if so advised.
Item 3.
Yes.
appeal against conviction, my lord, the section 302 and 326 and 380, my lord. The appeal may be admitted, record may be performed.
Heard Mr. P. Kataki,
Yes,
learned counsel for the appellate, who submits that this is an appeal against the judgment and order dated 20/12/2025, passed by the learned sessions judge Chirang in sessions case number 33 of 2023, filed by the appellant, whereby he has been convicted under section 302 IPC. You are A1.
A1, only one accused, man.
Okay.
Solid.
And sentenced to undergo rigorous imprisonment for life, along with fine of rupees 50,000 with a default clause. What about the other sections?
Other sections, my lord, they were also sentenced, my lord, for section 326, 7 years, I think. And for 380, my lord. 380 also. 380, yes, man. Theft was there. Imprisonment for 3 years, man.
They are to run concurrently.
Concurrently.
What about the fine?
Fine, my lord,
Except for the fine.
except for the fine. The
The
fine
learned
will-
counsel submits that the appellant has also been convicted
Learned
under
counsel.
section 326 IPC and sentenced to rigorous imprisonment for 7 years with fine of rupees 20,000. And also further convicted under section 380 IPC and sentenced to rigorous imprisonment for 3 years with fine of rupees 20,000 with a default clause. So all the sentences except for the fine has been directed to run concurrently. Next panel, that the appeal be admitted. Call for the TCR. Issue notice to the state. Mr. R. Kaushik, learned additional PP, accept notice. Have you received copy? Any IA?
I is there, my lord. It will take time after receipt of records, man. Not a
List
good
the
case for-
matter. Again,
Eyewitnesses are there, my lord.
on receipt of the TCR.
Eyewitnesses are the implicated me, my lord. Not a good
Okay.
case for anyway, my
In the meantime, we will file objection.
they will file objection.
Should we issue notice on the IA?
Yes, yes.
Give the IA. Heard Mr. P. Kataki, learned counsel for the applicant, who submits that by filing this application, the applicant seeks the suspension of the sentence passed by the learned sessions judge Chirag in sessions case number 33 of 2023, by which the applicant has been convicted under section 302. On being convicted under section 302 IPC, as well as under section 326 and 380 IPC, have been sentenced to undergo rigorous imprisonment for life. Issue notice. Mr. R. Tawfiq, learned additional PP, accept notice. And therefore no formal notice is required. List the matter along with the main appeal. List the matter again along with the main appeal. The state may file objection to the IA. In the meantime, we shall advise. All right, next.
Item 4,
statutory appeal, my lord, accused, appellant was convicted under section 6 of the POCSO Act for 20 years. And this is, my lord, may be admitted in the notice may be issued. The court may be called for.
Art Mr.
Jai Hussain.
J. Hussain, learned counsel for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment and order dated 1/12/2025 passed by the Court of Additional Sessions Judge cum Special Judge POCSO, Morigaon, in POCSO case number 141 of 2024. Corresponding to Mikir Beta TS case number 121 of 2024. By which the appellant has been convicted under section 6 of the POCSO Act and sentenced to undergo rigorous imprisonment for 20 years. Rigorous, you cancel, huh? To undergo sentence, to undergo imprisonment. Okay, it's RI. It's okay. To suffer rigorous imprisonment for 20 years. And to pay fine of rupees 15,000 with a default loss. Admit the appeal, call for the TCR. Issue notice to the state as well as to the complainant. Now, Mr. R. Kaushik, learned additional PP, accept notice on behalf of the state. Petitioner appellant to take steps for service of notice upon the respondent number 2 by submitting a copy of the memo of appeal to the registry. Stop the registry shall thereafter furnish the same along with the notice to be served to the respondent number 2 to the office of the additional PP, who shall cause service to the respondent number 2 to the officer in charge of the police station concerned. Stop the officer in charge of the police station concerned shall report back to the same office. This is the matter again on the receipt of the LCR.
Well, IO is there. Notice
Art-
may be issued.
Heard Mr. So-and-so, learned counsel for the applicant, who submits that by filing this application, the applicant seeks suspension of the sentence of the sentence dated 1/12/2025 passed by the learned special judge Morigaon, Assam, in POCSO case number 141 of 2024. And for release of the applicant on bail pending consideration of the appeal. Issue notice to the state as well as to the complainant, Mr. R. Kaushik, learned issue PP access notice on behalf of the state. The applicant shall submit a copy of the application before the registry, and the registry shall furnish the same to the office of the additional PP along with the copy of the notice to be served to the respondent number 2. The office of the additional PP shall thereafter serve notice to the respondent number 2 complainant through the officer in charge of police station concerned. Officer in charge of police station concerned shall report back to the same office. This again along with the main appeal.
Item 5.
Basically, okay, here the appellant was convicted under section 6 of the POCSO Act. And charges are against him is a rigorous imprisonment for 20 years and a fine of rupees 50,000.
Judgment date
Judgment was passed on
November 12th.
12 November 25. 12 November 25.
12/11.
All right, you are Mr. Hussain. Your name?
R. Hussain.
Heard Mr. R. Hussain, learned counsel for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment and order dated 12/11/2025 passed by the Court of Additional Session Judge, come Special Judge POCSO, Kamrup Metro, Gauhati. In session special case number 41 of 2024. Arising out of the Basista PS case number 261 of 2022. By which the appellant has been convicted under section 6. Conviction is under section 6.
6 of POCSO Act, as well as section 376 of 3 of IPC.
Section 6 of the POCSO Act, as well as under section 373 of the
376 subsection 3 of IPC.
376 bracket 3 of the IPC.
Yeah.
And on his conviction, he was sentenced to undergo 20 years rigorous imprisonment and to pay fine of rupees 50,000 with a default clause. Stop, no separate sentence as was passed under sections 376 bracket 3 IPC. Next para, let the appeal be admitted. Call for the TCR, issue notice to the state as well as to the complaint. Mr. R.R. Kaushik, learned additional PP accept notice on behalf of the state. Then remaining, so I think we can repeat that. Any IA?
No.
No IA.
Item 6. Convicted under section 366 for 10 years and 20 years under section 6 of POCSO. The sentence part is case number 44, para 50.
Para number?
Para 50.
What is 366? Kidnapping. Hard, Miss P. Boro,
Bora.
P. Bora, learned counsel for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment dated 6/11/2025 passed by the Court of Additional Session Judge cum Special Judge POCSO, Morigaon, in POCSO case number 93 of 2024, arising out of Nikir Beta PS case number 36 of 2024, by which the appellant has been convicted both under section 6 of the POCSO Act as well as under section 366 IPC. Stop, for his conviction under section 366 IPC, the appellant is sentenced to rigorous imprisonment for 10 years and to pay fine of rupees 5,000 with a default clause. Stop, for his conviction under section 6 of the POCSO Act, he has been sentenced to undergo rigorous imprisonment for 20 years and to pay fine of rupees 15,000 with a default clause. Both the sentences, except for the fine, has been directed to run concurrently. That the appeal be admitted. Call for the TCR. issue notice to the state as well as to the complainant. Mr. R. Kaushik, learned additional PP except notice on behalf of the state. Remaining thing will be said. Any IA?
Lordship.
Miss P. Bora, learned counsel for the applicant, who submits that by filing his application, the applicant prays for suspension of the operation of the judgment and sentence dated 6/11/2025, passed by the additional session judge cum special judge POCSO, Morigaon in POCSO case number 93 of 2024, by which the applicant has been convicted and sentenced to undergo rigorous imprisonment for 10 years under section 366 IPC and for with fine of rupees 5,000 with a default clause, and to undergo rigorous imprisonment for conviction under the section 6 of the POCSO Act with fine of rupees 15,000, the default clause. And issue notice, same thing.
Item 7. This is a criminal appeal against conviction in a POCSO matter, Lordship, under section 6 and 448 of the IPC.
Today is POCSO day. What is the date of judgment? December, okay. Miss
And Begum.
N.
Begum.
N. Begum, learned counsel for the appellant, who submits that by filing this appeal, the appellant has challenged the judgment dated 10/12/2025, passed by the Court of Additional Sessions Judge cum Special Judge POCSO, Morigaon, in POCSO case number 55 of 2024, rising out of Moira Bari PS case number 31 of 2024, whereby the appellant has been convicted under section
448 IPC and under section 6 of POCSO.
448 IPC as well as under section 6 of the POCSO Act. What is the conviction?
20
Sentence?
20 years, Lordship.
POCSO.
Yes.
And for
And to pay a fine of rupees 15,000 in case of default, and for 448, 1 year. Both the sentences are to.
any fine?
Yes,
Any fine under 448?
no.
1 year. What did I say? Last line. Stop. For conviction under 448 IPC, under section 448 IPC, the appellant has been sentenced to undergo 1 year imprisonment. Where is that? Where is that 1 year? I don't see that 1 year.
Base 80 plus 5.
Okay, rigorous imprisonment for 1 year. Under 1 year. And for conviction under the POCSO Act, rigorous imprisonment for 20 years. With fine of rupees 15,000 with a default clause. Next para, let the appeal be admitted for the TCR. Issue notice to the state respondent as well as the complainant. Mr. R. Kaushik, learned additional PP, except notice on behalf of the state. Stop appellant to submit a copy of the memo of appeal before the registry of this court. And the registry shall thereafter furnish the same to the office of the additional PP along with the notice to be served on respondent number 2 complainant. Stop. The office of the additional PP shall thereafter cause service of notice to the complainant through the officer in charge of the police station concerned. And the officer in charge shall report back about service of notice through the same office. List again on receipt of the TCR.
Lordship, notice can also go in the IA.
Heard Miss So-and-so, learned counsel for the applicant. We submit that by filing this application, the applicant prays for suspension of the execution of the sentence. Dated 10/12/2025, passed by the Court of Special Judge POCSO, Moregaon, in POCSO case number 55 of 2024. Whereby, on being convicted under section 448 IPC and under section 6 of the POCSO Act, the applicant has been sentenced to undergo rigorous imprisonment for 20 years. With fine of rupees 15,000. Next matter issue notice. The same thing you can repeat from the main appeal. Then last line will be list again along with the main appeal. All right.
For order, item 9.
May I please, your Lordship?
Mm.
As per the office note dated 10/12/25, Lordship, the addressee has left the RTS, so it's not served. Is not served. We'll obtain the correct address and will take fresh steps.
Office note dated 10/12/2025 indicates that notice issued to the sole respondent has not been served and the same has returned back with the postal note bracket, the bracket inverted comma open, addressee left RTS, close inverted comma. Stop. Learned counsel for the, this is an appeal,
Lordship,
appellant, Mr.
K. Jain, Lordship.
K. Jain submits that he may be allowed to ascertain the address, new address of the respondent so that he can take first steps. How much time?
Lordship, 2 weeks.
Considering the prayer petition, the appellant is granted 2 weeks' time to ascertain the correct and or new address of the respondent and to take fresh steps by speed post.
Lordship,
List again. After 4 weeks.
much of.
Mr. Jain, wait, what is this IA?
Passed by the set state.
What is to be done with the IA?
Lordship, notice may be issued in the IA. Or Lordship will take fresh step, then notice may be issued.
Notice has not been issued in this IA till
Lordship,
now. What
we'll
is
wait
to be
for
done?
the correct address to come, then Lordship may issue notice.
You want an order now or later on?
Later on, Lordship.
Okay.
Much of.
Item 10. Lordships, we have entered appearance on 30th of January, and the appeal is ready for hearing.
Where?
The opposite party has entered appearance on 30th of January this year, and the appeal is ready for hearing. The trial court's record has been received.
You're for the opposite party.
Lordship.
Matrimonial appeal.
Yes,
Any requirement for paper book and all that?
I think not necessary. Need not be.
Not necessary.
Since TCR has been received, my friend is also ready. Let it be posted for hearing any convenience day.
No, that we have understood. We post it for hearing And on the date of hearing, don't say that paper book is required. Again, we go back again to that stage. That's why I'm asking you now,
Yes.
whether there's any requirement for paper book. If you say no, we'll record that and post it for hearing.
Pardon. We have to verify the TCR, otherwise.
Mr. Mondal, you have to give us an answer. Only giving a smile will not do.
After some time, just we go through the TCR. If there is a vernacular, then it will be required.
This is your appeal, isn't it? Your appeal.
Yes.
So you should be knowing what is there, what is not there.
Sorry, we have not seen the TCR.
Without seeing the LCR, you have drafted the appeal.
No, record is available, but the others, documents, if there is any vernacular, statement of the PWs.
The positions are in English type, but there are a couple of exhibits, couple of exhibits.
Yes. Then it requires paper.
Couple of exhibits, 7 of.
Paper book.
Yes.
And you'll pay the cost.
Convenience. Convenient.
Mr. M.U. Mondal, Learned Counsel Affairs for the appellant, while Miss
V Rai on behalf of
V?
V. V for
V?
victory.
V what?
Rai.
Paper book.
V for victory.
V Rai.
V Rai. On behalf of Mr. A.K. Rai.
Well, Miss V Rai, Learned Counsel appears on behalf of Mr. V.K. Rai.
A.K. Rai.
I'm sorry, A.K. Rai, for the respondent. Stop. It is submitted at the bar that the TCR has been received. And that paper book would be required. Stop. In view of above, a registry to prepare the paper book expeditiously at the cost of the appellant and list the matter in the orders column once the paper book is ready and furnished to the parties concerned. Probably after paper book is convenient. Later on, they should not come and say that the paper book was required. Waste lot of time.
Please, your lordship. With due apology, my lord, I am appearing on behalf of Mr. M. Ahmed. He has some personal difficulties.
You're appearing with apology.
My lord, because I am not signing the.
Where is apology and where is you? Why?
My lord, he has some personal difficulties. So
Who has personal difficulty?
Mr. M. Ahmed.
Hey, Mohammed,
This matter may be taken up other time.
what happened to him?
My lord, the matter listed today after mediation, my lord.
But mediation was successful.
Yes, your lordship, some condition is there. My
Successful. How it is successful?
lord, kindly see the clause 3 of the mediation event. Report.
No, what transpired in mediation, that should also be informed to us.
Yes, your lordship, he will better.
Now, if it's successful, then we can dispose of the same
Well,
in terms of the agreement made by the parties. Have you entered into any agreement or settlements?
well, it is settled, my lord.
How?
But, my lord, matter may be taken up his present, my lord. Near that day.
No, definitely, we're not taking up just now, but I'm asking you,
My lord.
was it settled?
Yes, your lordship, it is settled.
So how it was settled? Where's the order or where's the settlement order?
Report is there.
Huh?
Mediation report is there.
Settlement deed, where's the mediation report?
Report R flag R. Clause 3, my lord.
Deed of compromise. Clause,
3.
there is no numbering. Okay, see. There's a copy there. When do you want it?
Well, first week of March. Would the parties like to appear before this court? Would the parties like to appear before this court? On the basis of the mediation? I'm just asking, they are not ready. Whether they would like to. Only order copy, withdrawal order copies, will be sufficient.
No, what we are saying is that apart from the counsel for the parties, whether your clients would like to appear before this court.
Because my lord, after withdrawal of the my lord, law court case, my lord. Then my lord, only submission of the certificate and her payment, the due payment. So my lord, that is sufficient, right? Not necessary. Not necessary, my lord. Only 2 lakhs paid and 6 lakhs remain. If they paid, he will pay money in the meantime, then my lord.
Who is going to pay? You're going to pay. Your client's going to pay.
And I'm appearing on behalf of wife, yes.
You'll be receiving.
Yes,
They have to pay you.
yes.
If they pay, then no payment is not required. Your good name?
M. Islam.
Mr. M. Islam, learned counsel, appearing on behalf of Mr. M. Ahmed, the appointed counsel for respondent, submits that since Mr. M. Ahmed has some personal difficulties to appear before the court today, the matter may be adjourned and be listed again on a convenient date. Stop. Your good name?
J. Bormondol, sir.
Ms. J. Burman, learned counsel, appears for the appellant, and she has no objection to the. Next para. It is seen that the matter was referred to the mediation center, and the parties have come to a settlement by way of a deed of compromise dated 7/1/2026, signed by them in front of the mediator concerned. So a copy of the deed of compromise is enclosed in this record and marked as R. To stop, the learned counsels for the parties submit that no, that line you cancelled. Next para, since adjournment has been sought for on behalf of Mr. M. Ahmed, let the matter be listed again on
First week of March, my lord, maybe on 6, my lord.
6th of March. 6th of March.
And you have less your lordships.
May I please, Lordship, this matter may be sent for mediation.
No objection, Lord. Matrimonial dispute. This matrimonial appeal has been arising out of a matrimonial dispute. Wherein divorce has been dismissed by the trial court, which has been filed by the husband. And husband is before this court.
Parties are represented.
Court mediation, Lordship. Both party wants to go to mediation as special mediation drive is going on.
Okay, so let me pass the order. Parties are represented by the respective counsels. And they submit that the parties are ready for settlement. For an attempt for settlement by way of mediation. To stop, this is a matrimonial appeal filed by the husband against the
Wife. Against
no.
the judgment and order passed by,
rejecting
rejecting the divorce prayer of the husband
rejecting the divorce prayer
made by the.
made by him. To stop.
Lordship passed in.
It's okay. In view of above, let this matter be placed before the mediation center expeditiously for an attempt for mediation by notifying the parties concerned about the date for mediation.
The notice was issued on 23/7/25, but there is no report regarding the service upon response number 2, the informant. It is a POCSO matter. So, the notice to be.
If you will enlighten us,
Madam, date may be given, madam, I will take instruction. Yeah, it seems, madam, we have not also filed the objection, madam.
okay, objection is one part, but regarding notice, how was it issued?
To the concerned OC, my lord, the learned PP may take the instruction.
No.
of that concern.
Please write office note dated 23/7/2025 indicates that notice has been furnished to the learned additional PP for onward transmission of the same to the respondent number 2 to the officer in charge of the police station concerned. On 23/7/2025. Mr. R. Kaushik Lanet, initial PP, prays for and is given 2 weeks' time to ascertain whether notice has been effected on respondent number 2 and inform the court. Records are there. What do we do about the paper book? We
Paper-
direct
Directed
at this stage.
Yes, sir.
Next para, since the TCR has been duly received, registry shall prepare the paper book. And paper book expeditiously. And list the matter again in the orders column. Once the paper book is prepared and furnished to the appellant and to the state. List again. After 4 weeks.
Item number 40, our objection is ready with the by tomorrow. Number 4.
Your objection is ready?
Ready, my lord. By tomorrow, we are going to.
Lordship also, since TCR has come, Lordship, preparation of paper book.
Mr. R. Kaushik, learned addition PP submits that the objection is ready and will be filed by tomorrow. Give the date. This IA only, isn't it? Item 14. Yes. What about the paper book?
Registry. TCR has been.
List again along with the main appeal. Then in the main appeal, right? Parties are represented by the respective counsels. And they submit that the TCR has come and the paper book will be prepared. Starting here for above, office to prepare the paper book expeditiously. And list the matter under the orders column. Once the paper book is ready and furnished to the rival parties.
Deeply obliged.
5 minutes. Just take a short break.
Number 15.
As per operational lordship, we have taken steps of notice on the respondent number 2 lordship. Report is awaited lordship
I'll take a statement. I'll file the objection.
from Mikirveta PS lordship. And in the IA, they have to file objection also lordship.
What about the appeal? What is to be done? Main appeal?
This criminal appeal 306 lordship, for notice on respondent number 2 lordship.
Notice is served?
No lordship, it has been sent, but report has not yet been received. lordship.
PP, any
I'll
information?
take a statement.
20 years. 20 years. sentence.
Receipt
20 years sentence.
20 years. lordship.
Please write,
Book stop.
paper book is ready.
Paper book ready lordship.
Just a minute. Paper book is ready and the copy of the same has been furnished to the learned counsel for the appellant as well as to the state. Stop. However, notice on respondent number 2 has not been effected till date. Stop. Peruse the office note dated 9/1/2026, which indicates that notice was forwarded to the office of the APP on 9/1/2026. For onward service on the respondent number 2. Stop. Next para in view of above, Mr. R. Kaushik, learned addition PP shall inform the court by the next date as to whether notice has been served on respondent number 2 or not. List the matter again after 2 weeks. Then in the IA,
Date may kindly be fixed lordship. IA for suspension of sentence lordship. They have to file objection also.
are you filing?
I will file by next day.
Mr. R. Kaushik, learned addition PP. Place foreign is given 2 weeks time to file objection to the IA. List again on so give a date. 11 March.
Apply.
16.
Appeal also 11 March. Earlier. IA and appeal 11 March.
As per Lordship direction, I have taken step upon respondent number 2. 250, but it was.
Pull down the microphone. Yes.
As per your lordship's direction, I have taken step upon respondent number 2 on
12.
2025, and it is not on record. LCR is also not received.
Objection has been filed. Die.
Here, we have informed the IO on 19/12/2025. Till now, we have not received any information. The next date, I will take the incident.
TCR was called by. Should we ask for a reminder?
Well, will require.
Mr. R.R. Kaushik, learned additional PP, prays for some more time to obtain instructions as to whether the notice has been served upon the respondent number 2 or not. Mr. Abhiris also seen that the TCR has not been received till date. Next para, in view of above, registry shall send a reminder to the trial court concerned to immediately send the. What is send, the scan copy or the original copy?
Original.
Oh, the original copy of the TCR forthwith. This is the matter again. 2 weeks. After 2 weeks.
Date may be fixed.
After 12.
Give a date on 16 March.
17.
May I please, my lord? My lord, I for delay, its short is delay only for 5 days, lordship. The respondent is services completed, lordship. So
No
response will.
Only 5 days.
Your good name?
A Dr. Lordship.
A. Datta.
A Dr. Lordship.
Mr. A. Datta, learned counsel for the applicant, submits that this application is filed seeking combination of 5 days delay in filing the connected matrimonial appeal. Stop. Mr. F. Hawk, learned counsel appearing for the sole respondent, submits that he has no objection if the delay is condoned. Stop. In view of above, the delay of 5 days stands condoned. YA stands disposed of as allowed. Then matrimonial appeal registered.
No, this is no.
Registered? No. Oh, not registered. But the order says appeal 9381. Yes.
That is the filing.
Filing the fire lordship.
Say the condom. Subsequent.
Then you write in the main appeal, in view of the order passed today in IASC number 2583 of 2025, condoning the delay. Registry to register the appeal. Then list the matter for admission.
Yes, lordship.
I think that order has to go in the IA, isn't it? Without number, how can we pass an order? You rewrite the order again, huh? It will be the IA. IA stands disposed of as allowed, huh? That is the last sentence. Remaining you cut. Registry shall now register and number the main appeal and list the same for admission. You want a date?
Yes, Lordship.
Give a date.
10 March.
On 10 March.
Deeply of this.
18.
I think we file objections.
You will file for your file.
We'll file one. Not file, but we will.
This is an application. Okay, before that, you heard Mr. A. Rahman, learned counsel for the applicant, who submits that by filing this application, the applicant seeks the suspension of the execution of the sentence order dated 15/9/2023, passed by the learned additional session judge Dubri in sessions case number 160 of 2018. By which the applicant has been sentenced to undergo rigorous imprisonment for life under section 302 IPC with fine and default clause, and rigorous imprisonment for 1 year under section 324 IPC with fine and default clause, and also rigorous imprisonment for 1 month under section 447 IPC. Stop. The learned counsel submits that all the sentences have been directed to run concurrently. Issue notice, next para. Returnable by 2 weeks. Mr. R.R. Kaushik, learned additional PP, accept notice on behalf of the
Respondent
state.
number 2 already represented, my lord.
Who is that?
My lord. One at Mr. A. My lord, A. Das. Name is reflecting in the progress.
What is the last line? Learned additional PP, accept notice on behalf of respondent number 1. And prays for 2 weeks' time to file objection. Petitioner, applicant to serve notice to respondent number 2. Where's the office? What is the name?
A. Das. Notice was served in the main case.
In this also you serve? Applicant to serve notice to the respondent number 2 through Mr. A. Das, who is the appointed counsel of respondent number 2. So the applicant shall obtain the acknowledgement of the notice from Mr. A. Das and thereafter submit the same before the registry as proof of service. Respondent number 2 is also at liberty to file objection if so advised. List the matter again on so and so.
17.
Yes.
19.
Delay condonation petition, delay of 426 days.
No objection.
No, but
But Lordship, POCSO, so private respondent is here.
I think the perhaps this case of also, in respect of only bail is required, I think. That's what a notification.
Criminal appeals also.
A criminal appeals in suspension of sentence.
This delay may be condoned in that case, Lord.
In that case, without service, that cannot be done. Or without giving the other side. So far,
Are you saying that insofar as delay is concerned,
Madam, that
The
mandatory,
delay can be condoned even without issuing notice to the respondent number two informant.
Madam, I'm not saying that, because that in case of bail, that is mandatory as per our notification.
No, that's what you're suggesting.
Yes, ma'am.
Bail notice required, appeal required, suspension of sentence required,
Required.
but for delay,
Delay, my lord, the service complete, notice may be issued, my lord, whether completion or not, that is not required. They are not coming, then it can be done, my lord.
we'll consider that later on. At this stage, we'll issue notice. Part Miss B. Sharma, learned legal aid counsel for the applicant who submits that by filing this application, the applicant seeks condonation of 426 days delay for preferring the appeal against the judgment dated 27/9/2024 and the order dated 1/10/2024 passed by the learned additional session judge special judge POCSO, Kamrup Metro in session special case number 226 of 2023, convicting the applicant under section 6 of the POCSO Act, as well as under section 376, capital A, capital B of IPC. And thereafter sentencing him to undergo rigorous imprisonment for 25 years and to pay fine of rupees 20,000. For conviction under the POCSO Act and for 1 year under, oh, sorry.
It's
Uh,
a default clause. 1 year is the default
Okay.
clause.
Then not required. What did I say last line? Rigorous imprisonment for 20,000. Stop. Next, where I issue notice to the state as well as to respondent number 2, bracket complainant. Stop Mr. R. Kaushik, learned additional PP accepts notice on behalf of respondent number 1 and submits that he has no objection if the delay is condoned. Next para. Issue notice to respondent number 2, bracket complainant. No, cancel that line, not required. Instead, you write applicant to submit a copy of the instant application before the registry of this court, and registry shall in turn furnish the same to the office of the learned additional PP along with the notice to be served on respondent number 2. Stop. The office of the additional PP shall thereafter serve notice to respondent number 2 through the officer in charge of the police station concerned. And the officer in charge shall report back through the office of the additional PP. Stop. Liberty is granted to the respondent number 2 to file objection if so advised. List the matter again on so and so.
Okay. Item 20.
Thirty-two days delay in preparing this appeal. Today is the first day, Lordship, so notice may be issued.
Heard Mr.
A.T. Sharma.
A.T. Sharma, learned counsel.
Sarkar.
I'm sorry. Heard Mr. A.T. Sarkar. There is beautiful handwriting here, so difficult to read. Heard Mr. A.T. Sarkar, learned counsel for the applicant. Who submits that by filing this application, the applicant seeks condonation of 32 days in preferring the connected appeal against the judgment and decree dated 17/11/2025 passed by the learned Principal Judge, Family Court, Dhubri, in FCTS bracket D, case number 46 of 2024, dismissing the petition filed by the applicant. Application was for divorce. For divorce. Filed by the, dismissing the application filed by the applicant for divorce. Next para, issue notice. Returnable by 3 weeks. Applicant to take steps for service of notice upon the sole respondent by speed post within 3 days. List again on so and so, give a date. The respondent will be at liberty to file objection if so advised.
21.
Maybe so. 51, 55 days delay, notice will go.
Where is the detail of the case?
My lord.
Case number, order dated.
My lord, it's in page number 6, my lord.
It should be available in page number 2 also.
Yes,
The cause title,
yes, yes.
or in the page number 1. That makes things easier, you see. Heard Mr.
Yes, that's all.
S. Das, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of 55 days in preferring the connected appeal against the judgment dated 3/3/2025, passed by the learned court of Principal Judge, Family Court, Dhubri, in FCTS bracket D, number 22 of 2023. Stop next para, issue notice, returnable by 3 weeks. Stop applicant to take steps for service of notice upon the sole respondent by speed post within 3 days. List the matter again on 23/3.
For hearing item 22.
Item 22, your lordships, I am seeking some accommodation today, not well, your lordship, in fact. That's why, otherwise I prepared, your lordship.
Pollution problem,
Your lordship.
weather and pollution.
Your lordship. 302, your lordship. 3 persons, your lordship. 3 active.
All right. Mr. S. Borthakur, learned counsel for the appellants,
Lordship.
submits that he is not in his best of health today and prays that the matter be adjourned
On the 11th of March, your lordship.
and be listed on a convenient date. Stop, Mr. R. Kaushik, learned additional PP. There's no objection to the there. Next, in view of above, in the, as prayed for, list the matter. I don't know. We leave it open,
Lordship.
but March.
March, your lordship.
In view of above, registry to list the matter in the month of March
Lordship.
on a date to be fixed by it.
Lordship. Deeply opposed.
Please, your lordship. I am not feeling well, so
You also.
I could not prepare the brief, lordship.
Everybody
I
is
may be
not
given-
feeling well.
I may be given 1 week time, lordship.
Think we also will not be feeling well.
My whole family is not well.
What is the matter regarding?
This is a life conviction, Lordship, 302, Lordship.
Okay, and when was he convicted? How long has he been in jail?
He is more than 1 year, Your Lordship.
More than 1 year.
Your Lordship. And two of the co-accused were already acquitted by this court, Your Lordship.
All right, we'll adjourn it today, but try to do the case as early as possible.
Lordship, Lordship.
See, the other day I had visited one jail and I've seen those live convicts. They are in a bad shape
Lordship,
mentally, like they have filed appeal, they want to know the results,
Lordship.
either this way or that way. So
So a week time may be granted, Lordship.
we'll list in the month of March. Date will be given by the registry.
Lordship, Lordship.
Okay. Mr. Your good name? Your name?
S. Dasgupta, Lordship.
Mr. S. Das Gupta, learned counsel for the appellant, submits that he is not feeling well today and is unable to conduct the case for hearing. Stop. He therefore prays for adjournment of the case and for listing the same on a convenient date. Stop. Mr. R. Kaushik, learned additional PP, appearing for the state, has no objection to the affair. Next para in view of above. Matter stands adjourned to be listed again in the month of March
Lordship.
on a date to be fixed by the registry.
Obliged, Lordship.
Yes.